Good morning, this is your Kelso Report for Wednesday, November 30th. I'm your host, Clark Kelso. We have two featured cases today, and both show what happens when you try to overreach procedurally. The courts have ways of making sure that the playing field gets re-leveled. In our first case, Lang versus Roche, the Second District faced the question of whether principles of equity and fairness permit the redemption of property purchased by a judgment creditor at an invalid execution sale, even though the statutory scheme characterizes execution sales as absolute. Well, it turns out the answer is yes. Even though the execution sale is absolute as a statutory matter, the doctrine of equitable redemption remains available to those whose fundamental rights have been trampled. The issue arose in the context of a remarkably brazen effort to use judicial processes fraudulently to deprive a neighbor of his property at virtually no cost. In 1995, Roche brought a defamation suit against Eric Lang, spelling Eric as E-R-I-C. Roche and his attorney represented to the trial court that Eric Lang was nowhere to be found, although first, Lang, whose first name was actually spelled E-R-I-K, lived next door to Roche. Second, Lang was regularly served at a post office box in prior litigation with Roche. And third, Roche knew appellant's mailing address since they had been next-door neighbors for almost 20 years. But, with the court's permission, summons was served by newspaper publication on Eric with a C. Lang, which of course was not his neighbor's name. After serving the process with the wrong name, Roche secured a default judgment for $50,000 in 1996. Then, 8 years later, Roche obtained a writ of execution against Eric with a K. Lang, which is when Eric with a K. Lang first learned about the default judgment. A sheriff's sale was conducted on November 19, 2003, and Roche purchased Lang's property for $100 since he was the only bidder. After more litigation between Lang and Roche, the Superior Court vacated the default judgment in 2008 on the ground that the fraudulent service by publication, based on a deliberate misspelling of Lang's name, rendered void ab initio every subsequent judicial act for lack of personal jurisdiction, including, of course, the default judgment. Finally, in 2009, Lang instituted a suit to quiet title. Roche tried to interpose the statutory judgment sale as a defense, arguing that the statute provides that an execution sale, quote, is absolute and may not be set aside for any reason, close quote. That's section 701.680 of the Code of Civil Procedure. Well, unfortunately for Roche, the California Law Revision Commission, which had drafted the enforcement of judgments law for the legislature, expressly indicated in its report on the bill that elimination of the statutory redemption right, quote, would not affect the equitable right of a judgment debtor to redeem from a sale at a grossly inadequate price where the purchaser is guilty of unfairness or has taken undue advantage, close quote. The language from the Commission's report fits the case perfectly. As the Second District explained, Roche was guilty of unfairness at every turn. He served the summons in the original action in a manner that violated constitutional due process guarantees. He sued Lang under the wrong name and told the court that Eric with a C. Lang was nowhere to be found, even though his intended target, Eric with a K. Lang, lived next door. Based on that misrepresentation, Roche received permission to serve process by publication under the wrong name, which led to the default judgment, and then to the writ of execution on Lang's property, even though the lawsuit and judgment were technically against someone named Eric with a C. Lang. The court concluded that, quote, there can be no doubt that a terrible miscarriage of justice occurred in this case. Simply put, Roche misused our state court system to seize his neighbor's land. As a matter of law, Roche has no defense to this lawsuit, close quote. Although it took a while for the courts to straighten out this mess, the good news is that right won out over might. The only bad news is that Roche and Lang are still neighbors. But the courts at least have leveled that playing field. Our second case also involves default judgments in Kim v. Westmore Partners, The 4th District reminds us that securing a default judgment does not give a plaintiff the unqualified right to simply collect on whatever damages were claimed by the plaintiff. A default judgment is not a blank check for the plaintiff. As the court explained, when a defendant fails to timely respond to a complaint, the first thing plaintiff's counsel should do, after offering an extension of time to respond, ideally, is review the complaint with care to ascertain whether it supports the specific judgment that the client seeks. If it does not, a motion to amend is in order. Well, in this case, plaintiff's counsel failed to conduct that analysis, and the allegations in the complaint, read in their entirety, did not support a judgment. The gravamen of the complaint was a breach of contract arising out of an alleged failure to pay on certain promissory notes. But the plaintiff actually attached the promissory notes to the complaint, and the terms of those notes significantly contradicted a number of the factual allegations in the complaint. Moreover, even if the factual allegations in the complaint did support a judgment in favor of the plaintiff, the trial court is not supposed to simply enter judgment in whatever amount is pled by the plaintiff. Instead, the plaintiff is supposed to prove up his damages with actual evidence. The plaintiff did not do that in this case, and the trial court erroneously entered a default judgment in the amount of $30 million, representing $5 million against each defendant. Because the plaintiff failed to offer to the trial court any significant evidence to support his damage claims, the plaintiff is precluded from obtaining a money judgment in his favor. And as a result, the 4th District reversed the default judgment entered in the plaintiff's favor. And to add a strong exclamation point to the court's judgment, the court sanctioned plaintiff's counsel a whopping $10,000, which earned the lawyer a referral to the state bar. Here's what the court said. Quote, "Those who practice before this court are expected to comport themselves honestly, ethically, professionally, and with courtesy towards opposing counsel. The conduct of Timothy J. Donahue, plaintiff's counsel, which included seeking an extension of time to file his brief under false pretenses, and then filing a brief which was not just boilerplate, but a virtual copy of a brief for another case, including a boilerplate accusation of misconduct against appellant's counsel, and a boilerplate request for sanctions based on a purportedly frivolous appeal, will not be countenanced. The attorney's response to this court's notice, informing him that we were contemplating the imposition of sanctions on our own motion, was both truculent and dismissive, going so far as to assert that we must have issued the notice in error. We did not." Close quote. And it went downhill from there. Strong words from the court, and a very strong reminder to the entire appellate bar about the level of professionalism that appellate courts reasonably demand. And now our one-liners. First to the area of criminal procedure. In People v. Velasquez, the 2nd District held that the trial court should have granted defendant's motion for acquittal on 2 of 3 counts of making criminal threats and dissuading a witness, because the victim failed to appear to testify during the prosecution's case in chief, and the sole witness was able to testify about only 1 of the counts. The victim did testify in rebuttal as to the other 2 counts, but the 2nd District held this testimony came too late, and the court reversed the convictions on those 2 counts. Next, in the area of criminal sentencing, in People v. Jerry Z., the 1st District held that a term of a plea deal struck in 1997, which was legal at that time, remained enforceable today, even though the relevant statutes have now been amended to disallow the term. In particular, the defendant had been convicted on 1 count of continuous sexual abuse of a child under age 19. He was granted probation with a 1-year jail sentence and various conditions, including sex offender registration. But the deal included a promise that if he successfully completed probation, and thereafter committed no additional offenses for a period of 10 years, the statutory registration requirement would be terminated. The court held that this promise remained enforceable, even though the statutes were amended to make such a probation condition unlawful today. Today, it's a lifetime registration requirement. Next, in the area of civil procedure and jurisdiction. In Yavapai Apache Nation versus Ipai Nation of Santa Isabel, the 4th District held that an Indian tribe's previous authorization of a contract and clearly expressed waiver of sovereign immunity for purposes of bringing claims in California court encompassed subsequent amendments to the contract, since those amendments were not a wholly new or independent contract. According to the court, the 4th Amendment did not displace earlier agreements. As such, the earlier waivers of sovereign immunity for the loan agreement transactions remained intact. And based on this holding, the appellate court reversed the Superior Court's decision to quash service of the complaint. Well, that's it for today's Kelso Report. Have a great day in the law.